right, good afternoon. This is Hap May with the Legal Play.
And I'm Chelsea El-Azzi, Hap's associate. Hap, today we are talking about trust litigation.
Okay, we can talk about that. I guess some fundamentals. What is a trust to start with? And a trust is a contractual relationship by which there are at least three parties: a grantor, a trustee, and a beneficiary. And that could be more than one beneficiary.
What do you mean grantor?
Grantor is somebody who gives something over to the trustee to hold in trust for the benefit of the beneficiary.
And it can be anything. It can be money.
Could be money, could be property,
Accounts.
could be accounts.
Okay.
Right, but some asset, some property is held. And there are a number of different kinds of trusts. The basic two divisions are what we call Intervivos trusts that are given, where the property is given over during the grantor's lifetime, or a testamentary trust, which is a creature that only exists springing out of the will of someone who has died. And basically it says, I leave the rest and residue of my estate
In trust.
in trust for the benefit of my minor children. Probably the most common form of trust that we see. It names a trustee. Sometimes it's a relative. Sometimes it's a trusted, business associate. A lot of times it is a bank trust department or some formal, trust company. That does, and there are pros and cons to doing that when we're setting up a trust, which is topic of a different topic, because we're now talking about, now that we know what a trust basically is, we could talk about what kind of litigation arises out of it.
So what kind of litigation arises out of it?
And the most common is there is a dispute between the beneficiary and the trustee. The beneficiary wants his money. The trustee is given some discretion to decide whether the beneficiary gets it or maybe not. And
I'd say in most trust agreements I've seen, it leaves discretion to the trustee whether or not to disperse.
And generally speaking, that's true. Although there are usually clauses that says, okay, during, until the beneficiary turns 35, and that could be a different number, but it was quite common, 35, then the trustee has the discretion to make distributions according to what we call ascertainable needs.
Right.
Health, education, welfare.
Yeah. And I mean that discretionary clause.
But after 35, that discretion usually, in most goes away.
And it's there for protections, like if there's creditors
And
that you don't want the money to go to the creditor, the beneficiary.
What we call Spendthrift Trust, yes.
So you will, wait until maybe that liability goes away before you make distributions.
Right, or only make distributions as needed for immediate needs in the process. That's all why a trust exists.
Right.
However, sometimes we get in a situation where the trustee who has what we call a fiduciary duty.
Yep.
Which is the highest duty owed by law. They have to look out for the best interests.
And I do think we did a podcast on fiduciaries.
Right, we did.
And one of them was trustees and the duties they have.
What that is, and the trustee has to account for the funds in trust. I mean, have to do tax returns. They also have to keep books and keep bank account records and investment records and
expenditures and all kinds of stuff.
Right, all of which, and I mean, they can't spend money. The trustee can't spend money on himself. The trustee can't engage in activity or investments that a prudent business person wouldn't do in the process. All of which is subject to some general rules of law and some discretions on courts, but the basic rules are there. The trustee has to look out for the best interest of the beneficiary, and make reasonably conservative investments with regard to how that is, so that there's no challenge as to whether the trustee, if something goes bad, has breached the I'm trying to think of the name of the rule, business judgment rule.
Oh, okay,
Business judgment
right,
rule, yeah,
right.
which he can
Like,
exercise. It has to exercise
you have
reasonable
to prove that
business
there's
judgment.
just horrible management, that
Right,
a reasonable person would
right.
know you shouldn't have done
Yes,
that.
yes.
Mhm.
And believe it or not, there are a lot of trustees that don't do that right. And there are a lot of trustees that probably are pretty close to doing that right, but the beneficiary doesn't think they're doing it right. So therefore, we get some situations where the trustee is accused of mismanagement, accused of self-dealing, accused of doing things stupid, basically violating the business judgment rule in the process, and to the detriment of the trust, and ultimately the detriment.
Well, and there's
beneficiary.
also the duty of loyalty, where you have to be loyal to the beneficiary.
Right.
And I believe that's treating beneficiaries equally.
If there's more than one beneficiary, then yes, and the trust document is going to rule how much discretion they have to give more to A than B or something, or whether they're just, there's no discretion to do that, that ultimately A and B have to get the same amount of money. Are all issues governed by the trust. And sometimes you see that too. Sometimes you see that the trust or beneficiary B complains about the fact that beneficiary A got all the money. And either that wasn't what the trust agreement was said was supposed to happen, it was supposed to be an even split, or if the trustee was given discretion, did the trustee abuse his discretion in the process? So that's we see that as well.
So usually in trust litigation, what I'm understanding is that it's usually the beneficiaries bringing the complaint, saying where.
Yeah, and that's true. That's true. Okay.
Where it's like, I'm not getting the money that I think I am owed. I'm pretty sure I should be getting distributions or some kind of payout at this point, and the trustee's not doing it.
Right. And that's a very common form. Sometimes the trustees will want to file a petition just for what we call declaratory judgment, to declare that if I take this transaction, the court has blessed it.
When you say if I take this transaction, the trustee?
Could be perhaps a lot of times you see that when they wind up the estate, or wind up the trust, where it says, okay, I have this amount of money left. I am going to give X dollars to beneficiary A, X dollars to beneficiary B, and Y dollars to the creditors.
Okay, now you're talking about, this would be a testamentary trust that comes out of a probate estate?
It could be an Intervivos trust that is ultimately winding down in the process. Sometimes particularly where we put assets, say that they put an apartment complex that dad had into trust.
Right.
And the trustee manages it, hires managers, operates it for 10 years. Then all of a sudden somebody comes along and says, I want to buy that apartment complex. Or maybe they're going to put a highway through it so that it gets condemned or something like that. And suddenly it's gone from operating an apartment complex to its money.
Yes.
And the trustee may say, or the trust provision may provide, or the trustee may want to just at that point in time make a distribution. And it may be necessary. There may be arguments as to who's entitled to what. And there may be some creditor claims to have to deal with. Sometimes it's easier for the trustee just to file a lawsuit, go into court and say, okay, here is what I plan on doing, giving this much money to the beneficiaries, giving this much money to creditors, and I want the court to bless it.
Is that a lawsuit?
That's a lawsuit, declaratory judgment usually.
Oh, right, declaratory,
Yeah,
right.
yeah, so I want to declare that this distribution, and then if a creditor says, no, I'm entitled to more, or beneficiary says, I was the good brother, he was the bad brother, I should get more. Let all of them fight it out. The trustee can just do what the court says.
Yes.
In the process, and that is a procedure which you see sometimes.
Okay.
In the process, and then there are also claims where the question is, when the trustee did something, was he doing it individually or as trustee? And you see cases about that where the third party says, well, I bought, this interest from the trust, even though it doesn't say the trust.
But if it is from the trust, it needs to say, you know, the trustee on behalf of the blah, blah, blah trust.
There's some odd Texas law on that I wish I could give you a clearer answer than that. But whether the trustee is presumed to have signed, if the trustee signs a document, if he's presumed to have done it as trustee, even though it doesn't say trustee, there is some case law that support that that's a possible outcome, and litigation may ensue from that. We see, you know, and we've got a case involved in this where a lot of times this happens with oil and gas interests, because that's a common thing that, you know, Texas great grandparents have put in trusts for their family members, and it becomes sort of family legacy with regard to that, particularly those people that were in Texas a long time ago and had ranches, and, you know, later on they discovered oil on their ranches, and now their grandkids, you know, are cashing royalty checks, or the trustee for their grandkids is cashing, which creates a series of trust issues and a series, and by that I mean a trust, not that we trust each other, but that there is a trust in place for which there are legal issues that you may need to get litigated.
Yeah.
And the litigation is your kind of your standard, you know, litigation process. Probate courts in Texas have jurisdiction over trusts. So in a lot of counties, we will see trust disputes brought in a statutory probate court.
Okay.
As opposed to a district court or, you know, a federal court,
is there
a county court.
Benefit to that or potential drawbacks to that?
Well, I mean, those who like to judge shop may have a different against us. Well, yeah, I like the probate judge. I don't like the district judge you would go to in the process. Yeah. It does have some advantage in the fact that the probate courts see a lot more of this action, this type of you know, lawsuit and stuff like that. So sometimes it's better to be in probate court. There are some situations where a probate court can pull jurisdiction. So if you file in a district court, the probate court may be able to transfer it. It's the only time I've run across in my experience where the court that is being the case being transferred to has the power to take it away from an existing court. Usually it is the existing court. It gets filed in district court, and then a motion is made to transfer it to a different county because the venue there's something wrong with the venue or jurisdiction or something to that effect. It is usually the court where it's filed in that has to rule, send it over. Probate court, though, has situations where they can actually take it from a district court and bring it into their court. And then whoever wants to put it in district court's got to go back to probate court and says, no, you need to remand it back for whatever legal reason there is in the process.
Okay.
You know, but there's, you know, a lot of money involved. There are a lot of different issues.
Yes.
With regard, sometimes we're dealing with minor children. Sometimes we're dealing with trustees. Sometimes they're bonded, sometimes they're not. In the process, and if we're dealing with a bonding companies will generally speaking go after a trustee who has done something that created liability because they have to put up their money and they want to try to get it back to the trustee, and they want to, as a matter of policy, go after what I would call the dishonest trustee, which we see that sometimes too. I mean, I have been appointed, you know, a receiver or a subsequent trustee where the original trustee has absconded. Just flat out absconded, not
money.
Just made bad investments or, you know,
transferred the money to himself and then
or his mistress or you know, something to, you know, something that outrageous in the process. And then, you know, sometimes we don't get full satisfaction with that because we sue this trustee who's, you know, grandmother set, or I guess the beneficiary's grandmother set up the trust and put him as trustee and didn't require any bonding.
That's common though. I feel like
that is common.
Especially if you're selecting an individual that, you know, maybe a family friend or someone, you know, that you're like, well, I don't want them to have to be bonded.
The kid's uncle.
Yeah.
You know, which is a common thing as well.
Yes, that's a consideration when you're setting up a trust.
When you set up a trust, you know, when you set up a trust, you got to trust the people.
Yeah, well,
You know, that was the subject of a different podcast, but that's, you know, but, you know, when you start requiring a bond, when you start requiring that the trustee be a trust company or the trust department of a bank, you're adding a lot of expense.
Yes.
So generally speaking, people prefer not to do that, but you run the risk of having somebody who is either not sophisticated, trustee who's not sophisticated enough,
or is very sophisticated.
Yeah.
And they know it, and then they take advantage of it.
Yes, and that's all the things you have to consider, and it leads to litigation.
And I feel like, Hap, you've seen enough of these cases, and you've just been in the business long enough. You tend to have a sixth sense for what's maybe happening, and
that's yes.
I've gleaned this from conversations with you.
That's
you just
yes.
kind of have a feeling.
Yes, or maybe I'm just the ultimate conspiracy theory, you know, pessimist, because I think there's, you know, something, you know, to quote Shakespeare, there's something rotten in Denmark.
Well, but that's how, like, a lot of the, you know, the legal movies, the litigation movies or TV shows,
Right.
that's usually how it gets started.
Right.
Is somebody finds something and is like, wait a minute, but these
Right.
don't add up. This doesn't feel right. There's something fishy here. And then you start investigating.
And generally speaking, people don't come to me when everything has gone right. You know, so there's usually something wrong. And a lot of times though, it's a lot of people don't understand the relationship. They don't understand that the trust document governs. Sometimes trustees don't understand that, don't realize, well, I can only do what the trust document and the Texas Estates Code or the trust provisions within the Texas State Code allow them to do.
Which, before entering into litigation, you need to exhaust your rights within the Estates Code and the Texas Code provisions.
Right. And that is just a procedural issue.
Mm-hmm.
And you know, beneficiaries don't understand that either. Well, gee whiz, Dad gave me a bunch of money. Why can't I use it? You know,
we can take some certain steps to at least make sure the beneficiaries get answers they're looking for, whether or not they like the answers.
Right.
At least they can have some trust that the trustee is doing what they're supposed to be doing.
Right. And you know, has accounting for what needs to be accounting. There's a procedure to demand an accounting from the trustee that gives them, I think it's 90 days. It's a trust was 90 days. The states was 60 days.
States was 60 days and
trust for 90 days. So you make that and see what you get. And you know, I mean, you can sue the trustee for failure to provide a proper accounting.
At least that's a foot in the door of the court.
They don't do that in the process. And you know, the court can take jurisdiction. The court can do a lot of things. Put a new trustee in, appoint a receiver, of which I've been done a number of trusts. I've been appointed a receiver of.
We've got a podcast on receivership too.
Right. And trusts are something that quite commonly are put into receivership in the process, and then the receiver can go after trustees who have absconded with money or parties that, you know, owe money to the trustee to the trust in the process, and or whatever other litigation there might be, that the receiver can then bring it on behalf of the trust, on behalf of beneficiaries in the process. And you know, this is not something that, you know, everybody has to do, but there is a lot of money and a lot of property and a lot of, you know, good reasons to set up a trust. It's just like any other relationship. You know, things can go wrong, and we're dealing with people who are imperfect, and so problems can be created and litigation ensues.
Okay. And that's trust litigation with Hap May.
All right. Hap May with a legal play. Thank you.